Recording.
Good afternoon, everyone. Thank you for joining us. My name is Claire Brulio. I'm the Communications and Business Disruption Resource Director for the Economic Development Collaborative, and it's been a while. I haven't been on our weekly Wednesday webinar, although it's Tuesday today. Anyway, we are joined by Nicole Ham and Hannah Swice from Fisher Phillips Law Office. And they're going to be talking with us today about how to mitigate risk of employees returning to work. This is a topic that we've had many questions about at the EDC, SBDC, a lot of employers and even employees calling in expressing concern of safety in the workplace. How do I protect myself? What type of PPE is required? And as employers, how do I bring my employees back safely? So we know that it is on topic and a subject of concern. And before we get started, just a couple things, a couple housekeeping things. There is a chat feature at the bottom of your screen. Everyone has been muted, so you will not be able to ask your questions verbally, but you can enter them in the Q&A, and we'll be going through those at the end. I'm joined by Emily and Brianne from Visionality. Thank you to them. They are the queen of and rock stars of all things webinar and Zoom. And they're joining me on the back end to help with any technical issues. So if you have a technical issue, you can use the chat feature and Emily or Brianne will respond right away. So we have about 27 people joining us today, but we had almost 90 registrants for this webinar. So I'm gonna give it one more minute before we get started. And just mention, you know, with the governor's new state orders and what we're currently waiting for Dr. Levin and the County of Santa Barbara to clarify how that impacts businesses, we're pretty sure that it's going to be in direct correlation with what the governor has released yesterday. We know that this has been a very difficult time for employers and for certain industries. And I just want to say that the EDC, SBDC is there for you. We offer no fee consulting services, and I will give out that information at the end. But if you are having any problems with cash flow or legal issues or concerns about how to get through this latest disruption, please do not hesitate to call our office. Okay, so we're going to get started here. I will disappear in a moment, hopefully, and I'm going to give this over to Nicole Ham and Hannah. Thank you so much again for joining us. They are both employment attorneys and experts in this area, and we are so grateful that they are joining us today. So, Brianne, let's give it to Nicole and Hannah.
Good afternoon, everybody. Thank you so much for joining us. We're thrilled to be here and to be presenting some additional information on where we're at today. This certainly has been a buzzword, an unprecedented time, particularly for employers. It's been really a roller coaster, and we at Fisher Phillips, being an employment attorney firm, we have 400 plus employment attorneys that exclusively work with employers across the country, have really had a front seat on this ride to help our clients and the community navigate these questions that have come up. We've really been just overwhelmed by the collaboration and the cooperation and the organization that our firm has put together. Immediately, we had a COVID-19 task force. We had an SBA loan task force, we had a central business task force, and we had a lot of experts that we could turn to and rely on for very timely and relevant and accurate information. And a lot of this has been unknown. You know, a lot of we're learning as you're learning. And so it's really been a process. But where we're at today, you know, we're several months in and still things are changing on a daily basis. So what we're going to share with you today is as current as it's possible for this moving target situation. And certainly if there are questions that come up after the fact, please feel free to reach out to me or Hannah at any point. Our emails are on the first slide, and then we'll give them to you at the end as well. And we're happy to be a resource for you. As I mentioned, our firm is national. We have over 30 offices across the country. And Hannah and I are just founding our Woodland Hills office, so our 6th California location. This is my 2nd day here in the office, feeling like I'm settling in and might be kicked out any minute. But it's wonderful to be here in Woodland Hills and to be servicing and providing support to our community out here, all the way out to Ventura County, Santa Barbara County, and beyond. And with that, I'm going to turn it over to Hannah to give us a little idea of the agenda we're going to cover.
Thank you, Nicole, and thank you, Claire. And we are very happy to be here today. And so today we're going to cover, as Nicole mentioned, really kind of some of the main things to look out for as, you're returning back to work or being told that you need to really go back. But what are really some of the things that you can do as an employer to help maintain a safe workplace, to have employees, follow your guidance, and, how to really have everybody working towards maintaining a safe workplace, and to minimize and help you minimize potential liability with this ever-changing landscape. And also some of the new obligations for many of the employers that have come down just over these past few months. And so we'll cover those. It is a lot of material. We've done several of these webinars together, Nicole and I have, and it's really a way to provide information. But if there's additional questions you have, please do ask them either here in the chat box or go ahead and follow up with us afterwards. We'd be happy to, speak to you further, answer further questions. So we'll get into the substance now, and I'll hand it back over to Nicole.
Great. So the first thing that I'm going to touch on are the orders and the guidance, and really the breadth of information that employers have to be digesting and attempting to comply with and aware of as it evolves and changes. And as an employer in California, it really is, it's like putting a puzzle together. You have to be conscious of federal law, state law, local law, and then what I call local law. So oftentimes there will be state guidance, and then there will be county, and then sometimes there will be city guidance within particular counties. And it really is putting something together from a lot of different resources, determining which applies to my company based on size, based on industry, what applies to me during this particular period of time, and how do I comply, and how do I provide benefits to my employees or protections to my employees that are usually the most generous under each of the applicable laws. So from a federal standpoint, kind of top down, employers need to be following CDC guidance, OSHA guidance, and guidance from other federal agencies. The CDC is constantly updating their information and actually recommends that employers should be checking their websites on a daily basis. So the CDC has put out information about testing, about protocol to implement, about cleaning practices. There's helpful Q&A available. And so that's definitely a resource to tap into. OSHA has chimed in with regard to claims that could be work-related for injuries in the workplace and ensuring a safe workplace. And some of the requirements, a lot of this is so uncharted, so a lot of the guidance that we're advising our clients on right now are pulled from other areas of the law, like FEHA, we'll talk about FEHA reasonable accommodation, and like the OSHA general duty requirement to provide the general requirement for employers to provide a safe and secure workplace. And what does that mean in view of COVID-19? And then California has its own orders. Claire mentioned the order that came out yesterday that pulled us back a little bit. There's also some relevant information that's very helpful that came out from the California Department of Public Health in mid-June, and it's titled Responding to COVID-19 in the Workplace. And we're happy to put up a link to it and also share that with you after, but while it does leave some open questions and is somewhat inconsistent with other guidance, it is a decent roadmap for employers as to what to do, or at least what issues to spot in the event that an employee either tells the employer that they've been exposed to somebody with COVID-19, has a suspected case, is experiencing symptoms, or is in fact tested positive. So that's a helpful resource as well. And then we have the local, so we have county orders and we have local. So a lot of cities will have orders in place. For example, there's LA County orders and there's LA City orders. And a lot of times they do mirror each other, but there are certain distinctions. And so as we were working with clients to determine who's an essential business, which businesses are permitted to reopen as we progress in the stages, those are different. You have to look at the applicable orders and interpret based on that. With regard to the California order that came out yesterday, no end date was specified, but it really triggered employers to reevaluate which operations may need to shut down and return to remote work only, which employees may be permitted to report to work, and what considerations employers need to take into account in view of the current status of our state. So essentially, in a nutshell, a lot of you, I'm sure, have heard the reports, but effective yesterday, all counties must close indoor operations with regard to dine-in restaurants, wineries and tasting rooms, movie theaters, family entertainment, zoos and museums, and card rooms. And then there's caveats, there's carve-outs for certain bars and breweries and pubs. And then in counties on a specific list, so the county monitoring list, which is they've been on that list for 3 consecutive days based on a rate of positive tests, are required to further shut down fitness centers, worship services, protests, personal care services, hair salons and barbershops, malls, and this is a little bit of a tricky one, offices for non-essential sectors. So the question of what's a non-essential sector and what falls under that, even for legal, it's questionable. It's legal in terms of being able to enforce somebody's legal rights and protections. But, does that mean on a day-to-day basis? What does that mean for accounting firms? And what really has to be done in view of these restrictions? And LA County, Ventura County, Orange, San Diego, there is a list of 31 counties that are subject to these heightened restrictions. If anybody ever has a question about what requirements they're subject to, or what additional considerations to look into, feel free to reach out.
So in addition to looking at, what is the state telling us you can do, what's the county telling us and what's the city telling us, it's important as we go back to the workplace to reevaluate what were the existing policies in place, before COVID, before we were faced with this COVID situation. And there's many areas that have now been affected by COVID, and they're areas that we should look at when we look at our written policies, and also areas that if we didn't have a written policy, we should really consider looking at again, and making sure that there is one, so that it's clearer. So one of those is sick leave, and Nicole is going to talk about that further because there have been several sick leave policies, new requirements. So if your sick leave policy, only has California or your locality, then you're going to need to look, is there other sick leave requirements under the new rules that I need to have and incorporate? So one of them is the FFCRA, for employers that have 499 employees or less. And we recommend having a standalone or having a written sick leave policy. And there's also been a lot of other localities that have passed sick leave, new paid sick leave. So that's one area to look out for. With regard to remote or telework, a lot of employers did have some form of maybe a remote work policy. But with this situation, mandating, remote work to the fullest extent possible, what you really need to do is look at what does my remote work policy say? And if you don't have one, we have one that we can share. But definitely looking at who is working remotely, what are they doing, what are, you know, the guidelines in there, and you know, having that clearer, because now maybe a lot more employees are working remotely. And then expense reimbursement, that's another area. So with remote work, we have seen a lot of new questions come up with regard to expense reimbursements. Before, you know, we were advising, you know, employers here in California, you know, reimburse for the cell phone, you know, possibly for the internet use. You know, there is, again, even this area doesn't have a lot of, you know, case law guidance. So now we're seeing, you know, where should you be reimbursing? People are using computers, printing, you know, ink. They're actually using their workspace at home. You know, all of those have now come up for question, should they be reimbursed? And then also, with regard to another area that Nicole will talk about a little bit more, is when you have employees, you know, either taking a test, or, you know, are they using their thermometer at home to take their own temperature? Should we be reimbursing them for their thermometer? These are new questions that have really come up during this time. And then with breaks. So breaks, looking at your break policy, allowing for staggered breaks, allowing for a new kind of breaking and additional breaking. Some of the orders actually provide for additional breaks. Also, another area is reasonable accommodation. And we've gotten a lot of questions that we will go through today, but this is another area. So for reasonable accommodations, employers have to look at their policy and really look to see what are some of the other potential reasonable accommodations that employers may have to make related to COVID. And I'll go through that more because I'll be talking about some of those questions. And then health and safety. There are specific requirements here in California. It's important to have a health and safety, you know, protocol in place. Some of the localities have health and safety protocols that are already set forth. You can have your own policy, but again, having this in writing is going to be, you know, really critical during this time. And it's mandated in several of the localities, is having a health and safety policy and protocol. And then harassment and retaliation. Another area that even if you have remote workers, there's still the ability for harassment and retaliation, not only just in the regular context, but related to COVID. We have seen the EEOC provide specific guidance about specific, in addition to harassment and retaliation, but also discrimination. You know, so there's that as well that has come out of this. And so the EEOC actually has provided some FAQs specifically talking about discrimination for persons of, you know, Asian or other, you know, national origin, that people may be taking actually adverse action against them. And so there needs to be a heightened awareness of that. And then looking at those. So these are all areas for harassment or retaliation if somebody takes a potential leave or complains about not having, you know, health and safety requirements that are mandated.
So Hannah was covering existing policies that employers should already have in place, and certainly any employer without written policies wants to work on that immediately. Compliant policies are first line of defense when it comes to responding to claims, defending the company, and having a compliant work environment in place. So that's number one. Number two is, what new policies does an employer have to consider, implement, and distribute to employees in view of COVID-19? And we've done two things at our firm. We've created back to work, return to work, or COVID specific policies and documents. And we also are preparing an employee handbook addendum. So some policies we don't want to incorporate into our existing employee handbook because either they sunset at the end of the year or we don't want them to be long-term, but they're relevant and they should be added for this period of time. So rather than part of the actual document, They're either standalone or an addendum to an existing document. So the first one is, Hannah mentioned, the Federal Emergency Paid Sick Leave and Federal Emergency FMLA. And I'm going to talk a little bit more in detail on this separately, but it's the Family First Coronavirus Response Act, the FFCRA. It's effective April 1. It caused a big stir because it impacted smaller employers, those with less than 500 employees, down to even one employee. And so for that reason, it really is important to be aware of the requirements and to have a compliant policy in place, as well as a leave request form, because there is the ability to receive a tax credit for the amount of paid sick leave provided, but in order to receive that, you have to have proper documentation. So we prepared a leave request form as well. Some of these documents are actually available free of charge on our firm's website. It's www.fisherphillips.com. And we have a resource center and database of available information and documents. So that's a great place to look. Our homepage has actually been turned into a COVID-19 resource center with updates, litigation tracker, a lot of really helpful information. So that would be a great place to start if you're looking for some of this information. It doesn't have everything, but it has some really great templates to work from. Certainly having a social distance protocol, what steps are the company taking in order to ensure a safe and secure and healthy workplace? What has been implemented in terms of markings on the ground, signs that have been posted, requirements not to come in if you're feeling sick or symptomatic, checking. I'm going to talk about screening and temperature checks, what processes they're going to be in we'll put that in writing. Reporting, who should be notified if an employee is not well or has been exposed or test positive. What is the follow-up going to look like? Are employees able to congregate in a conference room, or is that going to be restricted? Or a break room? Is the coffee maker still going to be available? All these little details should be identified in a social distancing protocol document. Down to the CDC pointed out that certainly handshakes and even fist bumps should be prohibited. So really we want to limit the contact, we want to limit the number of people in communication with each other and in person, in the elevators, kind of thinking that through is going to be very important. The LA County and other county orders have a very helpful addendum, and a lot of them are industry specific. And the addendum has, a lot of you have probably seen this, a checklist of protocol that a company may implement. It's not necessarily the case that every single box has to be checked, because a lot of the language says as practicable, as possible, to the extent feasible. But it's a good overview of items to be considering and protocol to see whether can be implemented. In terms of PPE, that also should be part of either the social distancing protocol policy or a separate policy. What's going to be required in terms of masks in the workplace, or masks on the job site if you have remote job sites, gloves, goggles, face shields, all these different kind of PPE that's available. What's going to be available, who's going to provide it, and where and how can it be obtained? And when I say who's going to be providing it, if the order requires the employer to provide it, or even if it's required now by state law, if the company is requiring the employee to provide their own, there's a good argument that that employee is entitled to be reimbursed. Or even if the employee decides to provide their own, you want to make sure that you're communicating that that's voluntary, that we will provide you with a mask or a face shield, and that if you choose to use your own, there will not be a reimbursement. Because these reimbursement claims, we're definitely already seeing them, and we're going to see quite a few more as we go forward. And I'll talk about a couple different areas this comes into play, but certainly with regard to PPE. It's a necessary business expense, and it has to be reimbursed under the labor code. Screening, temperature checks, and testing, if there's going to be a certain policy in place and protocol for doing so, that needs to be in writing. The employee should sign to acknowledge that they understand and will comply. If you're going to be asking employees to self-check, that needs to be documented. One thing that may not have come up for a lot of the people listening is with regard to the California Consumer Privacy Act. That's an act that went into effect January 1, but the enforcement went into effect July 1. And as it pertains to this area, it doesn't cover every employer, but it does cover many, many employers, particularly if you have a online presence, you're most likely going to be covered. And online presence can oftentimes just mean having a website. You're going to be covered, and you want to be providing employees a CCPA, Consumer Privacy Act notice that you're going to be collecting certain personal medical information about the employee or the customer or the vendor or the supplier or the visitor or anybody coming into the workplace or the job site. There should be a notice provided, and I believe there's a form on our website of this form to take a look at. And we've constantly updated it as new information has come in as well. So make sure that you're using the most current version of this form. An employer wants to also have written protocol as to reporting and returning after COVID-19. So I mentioned who should be the point person for collecting information about employees who are symptomatic, have returned to work, when can they return to work, what's the requirement, and there's different requirements between non-essential workers and essential workers in terms of those who may have been exposed to somebody with COVID-19. So it's a very different analysis. And in terms of the notice, we are recommending that employers err on the side of transparency and notify employees, even if there's a suspected exposure, a suspected or some sort of reason to believe that an employee may have been exposed, to provide a notice to employees and maybe customers and maybe vendors or maybe anybody who have been in the workplace, but certainly to employees. Also consider, do you need to notify building management? You know, how far does that notice have to go? But we have drafted quite a few different versions of this, whether there's a positive test result in the workplace or whether there's a suspected or possible exposure, and what are the steps that are going to be required for the coworkers, or maybe somebody who wasn't actually working with that employee but used the same workspace during a different shift, and how should that be implemented? So that's something to be aware of. And the reason that we're erring on the side of transparency and providing this notice is it's multi-layered. One, certainly word will most likely get out. You would rather be messaging that than gossip or through the grapevine. And then two, back to that OSHA general duty requirement to ensure that safe and secure workplace, that goes to that. And we're concerned about OSHA possibly auditing companies or investigating companies that have been on notice and not communicated this information to those in their community. And then the IIPP COVID-19 addendum. So we have amended our injury and illness prevention plan document to address COVID-19. And so that's something that should be updated, it should be in place, and it should be tailored to the specific company, specific industry, and what steps are being taken. And then lastly, we're also finalizing our employee handbook addendum. And that's, again, that separate document that will be attached to your employee handbook for the duration of this pandemic, at least as it's relevant for where we're at right now.
Okay, so that's a lot, you know, that to look at, to implement, to see what you need to do, and then, you know, how do we implement these changes with everybody and so that they're aware of them. So we're really going to have to do the next piece is to also train everybody on what are these new policies that we have. How are you supposed to wear that protective equipment that we're providing? You know, what personal protective equipment are you going to be wearing if you're in this position or that position? When can it be removed? All of those things are going to really need to be, you know, clear to the workforce and to management. So really, who should provide the training? Well, that's going to really depend on your workplace, but who should receive the training? Most definitely everybody should. And it's really key that management level positions receive the training and then are able to train and be able to talk to employees about any questions they have as well. So management and employees need to be trained on everything. So what have we seen? So, we can't gather everybody, as Nicole mentioned, into a meeting room anymore and provide one big training on site. So what are we seeing? We're seeing a lot of different methods of training. We're seeing, maybe an online module and doing some sort of interactive kind of acknowledgement of the training and understanding of it. We're seeing, internal type of webinars with a lot of workforces, which you can really just put together a PowerPoint of all of what you're doing and the changes you're making, and, put that into a PowerPoint and have that, out there. You can do it in a Zoom. There's so many different ways to, connect with your workforce and get this information to them. But one other part of this is, again, using these documents and having all of this in place as you are looking to help protect yourself as a business. Having a way for employees to acknowledge that they received this training. So having a training certificate, acknowledgement of the training. So that should be at every level. Whoever was attending the training should acknowledge that they had attended on the date they attended, what the training covered. All of those pieces are very helpful. And so that's really another big part of making sure that, employees are following what is the reporting structure when something happens. This will help ensure too that your workplace is safer, because people have a better idea of what they're supposed to do and what are the guidelines.
And then beyond training, how are we going to further implement these new protocols? And this is going to be part of your written protocol, is we have postings in the workplace. We have notices to employees. We have directions on the floor to drive traffic. We have limitations on how many people can use a particular area at a certain time. If meetings can take place by Zoom or digitally, we're going to encourage that. If remote work can be performed, we're going to encourage that. Plexiglass shields, the pre-work screens is a very important one. We're going to talk about that a little further as well. But implementing these protocols, so it's the writing, it's the training, and then there's the physical implementation of these as well. And certainly there's a lot of different places that you can get this signage, these items. I know the California Chamber has issued some of the counties have free information that can be posted, that can be downloaded and just, printed and hung in the workplace. And that's all that's required, at least for now. But certainly, we're seeing it everywhere. And it's something that is really critical to remind employees of their obligations.
Yeah, and just one that also is just regarding, the third party pickup and delivery. That's another big one. I think, that before, as we had a lot of, workers on site, this is one that's changed a lot. There used to be dry cleaning and food delivery and all of that. That's one, I think, a big area as well.
Agreed.
So yeah, so we're going to cover some of the questions that have come up, and this has really been a big area. And a lot of employers, trying to navigate through these questions, and it's been hard because a lot of them don't have clear answers. So, when an employee, you're ready to bring employees back, and, there's been several responses, we've had to talk through with employers, and just a lot that have come up. So we're going to really talk through some of the main questions that have come up in this area. So an employee wants to stay home to take care of a sick relative. The relative hasn't been diagnosed with COVID-19 and was not told by a healthcare professional to self-quarantine. Can the employee do that? So as an employer, again, this is not a clear answer. So we now are, with this COVID, we now see that there's individuals that are in a high risk category, and somebody that, is elderly may be in a high risk category. or somebody that just is, you know, immune compromised can be in a high risk category, or pregnant. So any of those. And so this really requires us to take a closer look. Because if you look at this, we're not necessarily required to, you know, provide an accommodation, but we need to look into it and do an interactive process with this person, because there might be an accommodation that we must provide in order for this person to care for this relative. Also, if they're having to care for the relative, does it trigger some other obligation? Again, you know, depending on the size of your business, then they may be, you know, able to take some job protected leave for a certain period of time. So again, that's one that is not a clear answer. You have to look at that closer if there's a relative that is in a high risk category. If the person themselves is in a high risk category, it also triggers other issues. And you have to be very careful in this area as well. So if you're recalling employees that are, some might be in a high risk category, you can't decide for them that they're in a high risk category, therefore they must stay home. So that's another area to be careful for. However, if somebody asks you, then you engage in the interactive process. Another question is, what, I don't want to come back because I'll be making more on, you know, collecting unemployment insurance benefits. So if that's the only reason the employee doesn't want to return to work because they're going to collect unemployment insurance benefits, then that's an easier one. It's a little trickier though if it's, I don't want to because I have a relative, and the EDD has actually put out some specific FAQs. So we would urge you to look at those as well. But if it was just the only reason that they had no other reason other than they were just going to collect more on unemployment, then you could go ahead in that situation and probably accept their voluntary resignation. But that's just one of the very few that is a little bit clearer. And even there, it's not entirely clear because you do really have to look to the totality of the circumstances and figure out, is that the only reason? So that's another one. Childcare issues, as Nicole will talk a little bit more about the FFCRA. Here there is, you know, there's been a special expanded reason for employers to provide leave for, you know, people to care for their children. And now that we have some more clarity as to what's going to happen through the end of the year, you know, there may be further expansions to benefits or protections. So with childcare issues, again, you know, it's really engaging in the interactive process and being flexible with those, and, you know, staying aware of what are the requirements under the FFCRA or otherwise. Covering the one with the elderly relative at home, again, it's not necessarily that they will automatically be entitled to an accommodation just because somebody is elderly or high risk at home. However, you have to really look at the circumstances. Do they need to care for that person? Is the person ill? You know, all of those things. And then, you know, again, if you do provide an accommodation in that situation, like providing expanded leave or unpaid leave, doesn't mean that you have to provide any kind of paid leave necessarily unless they have paid leave, but it's really exploring what are the accommodations. Can we continue remote work or any of those things? And then with the person that doesn't feel safe or is just scared, again, there's no clear answer here. It's again, engaging in the interactive process. Did this person, you know, potentially have some other, you know, issue that has been exacerbated now by COVID-19, which makes them feel scared, or they have, you know, anxiety or some of those other areas. So again, this one is not an area where you can just say, you know, that's not a protected reason that you think of right away. Like, I'm scared, therefore I'm just going to go ahead and accept your voluntary resignation, or you're scared, therefore I'm going to terminate you. That's not a basis. We have, you know, a health and safety policy in place. But, you know, again, I think the big takeaway here is having a dialogue with individuals and really talking to them about what you're doing. And I think having, a lot of these, safety practices in place, letting employees know that you're very on top of the situation will help people feel safer anyways. And having policies and all of those things and following kind of the guidance will help ensure people feel that they're safe. And then having just an open line of communication is really key. And you should document this. So all of this should be documented because, as we'll talk about a little bit later is, we're seeing the rise of, claims starting from COVID. And we want to really document this. You always want to document the interactive process, not just COVID related, but you always want to document the interactive process you've had with employees and really exploring reasonable accommodations. Maybe your business has been so badly affected that, again, you have to look at what is being asked of you and what is possible. But again, it's going to really be looking through, talking through this with somebody and then, going through it. So I did want to point you to 2 FAQs that are helpful. There's a lot of them, so I'm not going to go through them all. But the EEOC, and we can share the links with you, the EEOC has provided some really good FAQs on some of these questions that have come up and what you can ask for if somebody's in high risk category, how do you kind of tread in this area? What are some of the accommodations you might want to explore with them? So those are really helpful. And then also the DFEH has provided some FAQs, which are actually pretty similar. But we'll go ahead and share those links with you. And then, one question we did get is how much sick leave can an employee take? And so that, again, is going to depend on your workplace. How much paid sick leave, obviously, is required by your locality, and then by your size, and then do you have additional sick leave through your company policy? So that's really going to be what you're looking at when you look at sick leave. And then I didn't know if you had anything else you wanted to add in this area, Nicole.
Yeah, I'll just throw in a couple of things. So Hannah's pulling, I said that we were taking terminology and guidance from other areas of the law because there isn't a lot of current guidance for us. And one of those things that Hannah's mentioned a few times is this interactive dialogue. And that buzzword, that terminology comes from the FEHA, the Fair Employment and Housing Act in California, and then the federal ADA reasonable accommodation requirement. So there's a requirement to engage in a dialogue, there's a requirement to provide a reasonable accommodation, and those are all standalone causes of action. So putting aside discrimination or retaliation or wrongful termination, a standalone cause of action is the dialogue itself and the providing of a reasonable accommodation that's not an undue hardship. And so we're looking to that law to direct us in this analysis. And the Fair Employment and Housing Act applies to very small employers. The discrimination and retaliation, if there's 5 or more individuals, not even employees, but the owner can be considered, independent contractors, 5 or more individuals. The harassment provision applies to those with just one employee. So that's one thing to consider. Another thing to consider is in this kind of morass of leave requirements are federal FMLA and state California Family Rights Act requirements, which is the protected time off for an individual to care for themselves or somebody else or to bond with a baby up to 12 weeks. And we talked about the emergency FMLA, which expands on that to take time off to care for a minor whose school is closed or childcare is closed. But that, this might apply to an employer in lots of different scenarios. Currently, the non-emergency applies to employers with 50 or more employees, but it's not currently. So if you had over 50 and you had to do a reduction in force or a furlough or a layoff, that doesn't mean you're necessarily not subject. You need to have a look back period of 20 weeks in the prior 12-month period. And so it may be possible for you to be covered. And there's also a pending bill to reduce the threshold for CFRA in California. And then lastly, that, it doesn't feel safe The reason to really drill down, really find out the reason, or one of them, is to avoid those retaliation claims. I complained about an unsafe work condition, and I was fired, or I was not brought back from furlough, or my position was transitioned, and that was retaliatory. And that can also apply if you're very small, down to just one employee. So definitely things to keep in mind. So moving on to the next topic. So what if an employee refuses to use PPE, undergo a symptom screening check, testing, or a temperature check? And these are somewhat different silos, but there's a lot of overlap. So it is recommended that if you're going to be having employees come into the workplace or go out to certain locations or engage with clients directly, at a minimum, have a symptom check, and ideally a temperature check as well. And temperature, certainly, you know, it's not the end all be all, neither is the symptom check, but at least it's a step that an employer can take to try to minimize the potential liability, and to try to contain our situation. So if that's going to be having employees go through a screening process as they enter the workplace, if they're going to be self-checking and self-screening at home before they go to a job site or before they meet with a client, that needs to be reported, documented with the proper CCPA notice to employee, and maintained in a separate file because it is medical related information. So you want to keep that in a separate file. With regard to the process itself, not only is it raising privacy issues, it's raising other wage and hour issues. And so for the wage and hour items to be aware of is the time it takes an employee to stand and wait in line to undergo their check, or to go for a test, or to go through any of this process needs to be paid time, because they're under the employer's control. And in California, that's very broadly interpreted. And even a de minimis, even a small amount of time could be subject to a potential claim. And so I've had clients say, well, you know, we're quantifying this and it's like 30 seconds. Even so, round up, pay for the time, put it on the time card and the pay stub, make sure that it's corresponding, and pay for that time, because we foresee quite a bit of litigation around that issue. If an employee is using their own thermometer at home, I foresee that being a reimbursement issue. So you may want to provide thermometers or reimburse for some percentage of the use of a personal thermometer. As you know, humorous as that might sound, it's not when you get a potential claim. I had one client where an employee refused to undergo the temperature check, period. And they engaged in that interactive dialogue, and they discovered that what would be a reasonable accommodation was letting the employee use their own personal thermometer rather than the one that the company had been using. So oftentimes it can be a very simple solution, but having that dialogue, documenting it, and coming up with that solution that works for everybody involved is recommended. And then if you send an employee home because they have a fever or because they have symptoms or for any other reason, there's potentially reporting time pay. Reporting time pay is where an employee shows up for work and is sent home before completing at least half their scheduled time. And it's an area that we've seen quite a bit of movement in the past, and I certainly foresee that coming in the future now, because if you're sending an employee home, they're not able to complete at least half their day's work, and they're eligible for at least 4 hours, no less than 2 hours, based on their regular rate of pay. And so that's something to be aware of and to compensate employees for. Also, if you're having employees call in to see if there's work, if work has slowed, and you can't schedule everybody on a regular basis, that could also trigger reporting time pay. And there's a recent case that came down that supports that, where employees just had to call in, and the court said that that was considered reporting to work, is the phone call to see if they were told to come in for the shift that day. Another accommodation issue to consider is, let's say an employee refuses to wear a mask. What's the reason? Is it health related? Is there an underlying disability that creates an issue with wearing a face covering? Or is it religious affiliated? And what possible accommodation could be offered? You know, is a face shield an accommodation? Or is there some other method, a different version of mask? We've heard issues come up with employees with hearing impairment who need to be able to read lips. What accommodation could be provided there? So every time there has to be this kind of case-specific individual analysis and a process to determine whether there's an accommodation that would not be an undue hardship on the company that can be provided, that would allow this employee to continue working with some sort of accommodation, or to go through the process that's required, but without pushing back. Just with regard to the testing, a quick note that the federal government has come out and confirmed that employers may not require antibody testing, but may still require viral testing. So you don't want to be requiring the antibody test as part of any sort of protocol or procedure, but certainly viral testing is currently permitted. Also consider in terms of the time, if it's required by the company, it's paid time, the company should pay for the testing. And questions have come up time and again about asking for actual test results. And we certainly we're very cautious about that, because the results may contain additional information that an employer is not necessarily entitled to, or raises other concerns, like if there's an underlying illness that's identified or medication the employee's on. I mean, also the possibility that, you know, health systems are so overwhelmed right now that requiring a doctor's note may not be feasible. So that's another consideration, and has been pointed out in a lot of relevant FAQs. But certainly, you know, getting a verbal acknowledgement that can be documented, a requirement that employees have to notify the company if they do test positive, and having that in place. We've also similarly had this question for third parties, contractors working with employees, and what's, you know, those third parties want that information about your employee and how to go about that. So we've handled that as well.
And so just one other area here is just, you know, getting consent. And I think, you know, we have a consent form sample if you'd like it, if you're, you know, conducting screening, testing, or temperature checks. And then going through a big one here is really, you know, what comes up, because as we've seen, you know, we were hoping the cases would go down, but we've seen cases go up, and, you know, which was reason for the order that was issued yesterday. So what happens if an employee tests positive? And actually, I authored this article. It is a guide to an employee with a positive COVID-19 case, you know, or a suspected case. You want to treat them really the same, and go to the employee who is sick or experiencing symptoms, making sure they're immediately sent home. You want to isolate them, and that they're going to be seeking, you know, a medical diagnosis to confirm whether or not they've had COVID. You want to ask them quickly, and if you go through this article, you'll see, but basically you want to ask them, who have they been in contact with, close contact, and close contact means within 6 feet, for 15 minutes or longer within the past 48 hours of the onset of symptoms. And so you're going to want to really figure out who it was. And so acting quickly here is really key. And then, as Nicole mentioned earlier, there are different guidelines, whether you are in the critical infrastructure or not. So again, looking at that. And if you go through this article, it really actually has all of these steps, and also links to documents that will help you also with regard to notice and things like that. So we've provided samples. So after you've gone through and identified who is within this 6-15-48 realm of the employee, then next you really need to address who you need to notify. And also, really, as you're doing this process and talking to the employee, you need to document if it was work related or not. And that goes to OSHA and Cal OSHA requirements. is actually figuring out, was this a work-related COVID case? And really looking at, there's some guidance we've gotten as to looking into the work-relatedness. And do we have a lot of other cases, or was this person ill because other family members were ill? And so looking at all those other factors. And then determining whether or not you need to record it or report it. California has different guidance related to reporting and recording. And then some of the localities have implemented very specific guidance. So LA County has just issued an order not that long ago that if you have 3 or more positive COVID cases that you're aware of within a 14-day span within your workforce, you need to actually contact the county's health department. So those are also items to look out for. And then cleaning and disinfecting is another key, and following CDC guidance in this area, because it can change. It has been pretty consistent, but it can change. So it's really important to look at that. And then also, notifying if it's either other employees that have been, potentially exposed, or also if it's third parties, or maybe a building that you need to, building management, whoever it is that you need to notify, you should do that. And then finally, would this person be entitled to sick leave? The person that's actually on the leave will most likely, depending on your company policy, what are this, what sick leave do they have left? Do they have any FFCRA sick leave left? Or were you ever, subject to that? Is looking at all of that. And then finally, just documenting that properly. And again, we have a leave request form. So I'm going to move on just so we could take a couple questions at the end. And so I urge you to look at this article because it's a helpful, quick guide.
Yeah, it's a great article. So we are short on time. I'm just going to mention that the FFCRA, in a nutshell, there's 6 categories that employees are eligible for emergency paid sick leave. They're fairly specific. The employee does have to be paid subject to a cap. And then certain categories are paid at 2/3 their rate of pay. And the emergency FMLA is the 12 weeks of time off to take care of a child whose care or school has been closed. We do have summaries that we can provide. If you want a detailed summary, email us after and we will send that to you so you can get some more information on this.
And then just really, this is the litigation risks. And as we've really covered these as we have spoken today, looking at what you're doing when you are either recalling or laying off employees, looking out for discrimination, retaliation, a lot of wage and hour concerns to look out for. So really, we have a litigation tracker as well at our firm, on our firm's website, if you're interested in seeing the uptick in COVID litigation. So we'll take a couple questions here if we can. And like I said, if we didn't get to your question now, we will look at them and we will respond to them. And you can also just reach out to both of us, one of us, feel free to do that.
Claire, did you want to jump in or should we go ahead?
Thank you. Can you hear me?
Yeah.
Okay, great. Thank you so much. That was a great presentation. And I just want to mention, you guys said this so much and I appreciate it. Document, document, document. I mean, I can't stress that enough. When I work with clients and they have HR issues, document everything. That's so important. I really appreciate both the time that both of you have spent in answering the questions that came in before. We have 4 now, but I would invite the rest of participants to type in your questions now and we will get through them very quickly. So one question here, do Hollywood sets and sound stages, both on location and studio stages, fall into offices for non-essential sectors and therefore need to close in Los Angeles, which I presume is one of the counties identified as one of the highly impacted counties? It has been identified as a highly impacted county. Yes. That's the question. Sorry, Emily, you have an answer?
No, I'm just marking it that they are going to answer it live. I don't have
sorry about
answers.
that. Sorry about that. Hannah and Nicole.
I'll jump in on this one. So yes, LA County is one of the highly impacted counties currently. In terms of this, there's a couple questions on this in terms of what are the non-essential offices. And there is guidance from both the state and federal as to what is considered critical infrastructure or essential business workers. And so you want to take a look at that guidance and see whether or not the workplace could fall into a category or does fall into a category. And when I say could fall into a category, it's possible that it may not directly, but it's supporting, the business is supporting a critical workforce or a critical infrastructure business. And so, for example, a client that provides valet services couldn't provide those services to a residential facility, but could provide them to a medical center. So it may depend on the particular use or function of the office in terms of whether they're considered essential or non-essential or supporting or in the chain of command for to essential businesses or critical infrastructures. Certainly, I'm not aware of a specific carve out for entertainment. I do know that LA County has issued guidance on reopening the entertainment industry, and there's a specific addendum on this. So if you want to take a look at that, we can certainly help with that. And we can also pull up that guidance to find out whether there's at least an argument of continuing to operate, certainly subject to safety protocol and everything that we've kind of mentioned in terms of the new practices and policies.
Thank you. Next question, let me go back here. Which businesses are offering health and safety coordinators to assist in accommodating the COVID-19 guidance?
So which businesses are offering health and safety coordinators?
Yeah, this came from Daniel, the same individual who submitted the last question. I'm not sure if it's a misunderstanding or...
Yeah, that's okay. So I think, basically there's online resources. And then again, there's also resources that you can just put together. There's no necessarily specific coordinator. However, you should, designate somebody specific to, for COVID purposes, for reporting purposes and things like that. But really putting these, plans in place, you don't have to have, you can really do this. And with the guidance of an HR professional or, us, really you can do this yourself though.
Okay. We have a few more questions here. I think this one is already answered, but I'll ask it again. Can you please provide more specific examples of offices that fall under the non-essential sectors? So where does that information live again?
Oh, okay. And we can actually provide a link. I think that might be helpful, is to provide you with the link that actually provides all of kind of guidance on this issue as to what would be essential, what's non-essential. And then again, as Nicole pointed out, there may be an argument that it supports an essential business.
Okay.
If you Google, we're happy to share the link, but if you just Google California Essential Workforce, I believe the first thing that will pop up under Google is this list. It's dated April 28th, 2020, and that's the California guidance. There's also federal guidance to take a look at, and we're happy to share that as well.
Thank you. Are there workplace harassment considerations for people previously diagnosed with COVID-19 and returning to work, similar to the protection for Asian employees?
Yeah. So yes, and that's a really good question. It's really important to look out for that, right? So now does nobody want to be around this person because, they were out because of COVID? You have to be really careful, again, that people aren't overly sensitive, right, to this as well. And so making sure you follow the protocol is really what's important. So really, again, having an open line of communication. If somebody is concerned, they should confidentially go to management and, express those concerns. But again, not being able to treat the person differently just because they had, contracted COVID, because this is coming up a lot.
And I'll add on to that, that there's another category under FEHA that an employer cannot discriminate against an employee for being perceived in a certain category. So perceived as somebody with a disability or perceived as somebody of a certain ethnicity. And so whether or not that person actually was diagnosed with COVID or had a certain medical condition or falls within a certain category, that can be irrelevant. But if they were perceived to have and there was adverse action taken based on that, that's another kind of hurdle for employers to be aware of.
Thank you so much. Okay, next question. Are you seeing organizations legally challenging COVID-related state and local mandates presented today?
So yeah, so I think there has been, again, we have somebody actually handles really like legislative issues at our firm and is really on the front line of those issues. But with regard to that, we've seen a lot of employers, businesses challenging, that's really what we saw with the FFCRA, challenging, that requirement, even challenging some of the local paid sick leave ordinances that have been implemented. And then in addition to that has been that workers' compensation presumption, which again has at this point expired, but there was a huge push against that, and there's a pending bill. But we are seeing a lot of pushback on some of this that is coming down or being proposed, that would hold the employer liable and those kinds of things, or presumptively hold the employer liable.
Interesting, thank you. Okay, last question. I want to be sensitive of your time. I own a catering business with almost all part-time employees. Do the rules regarding number of employees apply regardless of whether the employee is part-time or full-time? In other words, if a rule applies to companies with 50 or more employees, is that 50 full-time employees or 50 regardless of number of hours worked per week?
That's going to depend on the rule. So certainly, for some purposes, whether the number of hours the employee works is relevant. For purposes of the Fair Employment and Housing Act and SIFRA and FMLA, it's just number of employees. It's not dependent on how many hours they work. And the same with the FFCRA. So you want to look at the specific law or regulation and then determine from there how to count the number of employees.
Okay, thank you. And we did just have a question pop up, but it disappeared. Michelle, I'm sorry that this seems vague. I think what some of us are looking for is very specific guidance on their business type. And so is that something that you can provide a link to, or is that something that needs to happen in a direct conversation with you? Or with someone spending a lot of time researching their own business type and how the rules apply to them? What would be your best guidance there?
So it really depends on the business type. There are some businesses that have clear guidance on what are the rules that apply to them, and we have covered those. And again, we could talk about those in a more direct conversation, I think. But we can definitely, like I said, with regard to some of this guidance as to who's critical, who's non-critical. But I think, again, that would be helpful. If you want to reach out specifically to us, we'd be happy to help you look at what is your specific business and what is needed.
Okay, great.
I'll also mention you might want to add yourself to our email list to get regular legal alerts, because that will help you stay apprised of the most recent changes. And on our website, we can there's a place to do that as well, and that's going to be helpful. And then anything beyond that, we're always available to answer any questions or discuss further.
Thank you, both of you. We are at 1:09. I just want to thank again Hannah and Nicole for the time that you've spent. You can reach out to them. FisherPhillips.com is the website. We will be, it sounds like actually on the EDC side, we'd like to put together an additional one sheet with this information so people know how to contact you. We'll put it on our website and distribute it broadly to our network and make sure that people are familiar, aware, and informed as these issues continue to come up, and we have this rolling impact of COVID-19 and an unknown of when this is going to be done. So that being said, any further comments or anything else you'd like to add, Nicole or Hannah?
Just want to thank you for having us today. And you know, we do know this is really a challenging time, and so I know a lot of times with attorneys, you know, they're starting their time clock, or we really want you to know we're a resource, and you can reach out to us, and that's not what we're we really want you to know that it is hard for people to navigate through this, and we want you to know we are a resource for that.
Thank you. And just as a reminder, I think most of you are probably clients of the EDC, SBDC already, but if you need direct free consulting services, you can call 805-409-9159 and get connected with a business advisor right away. So with that, I want to thank you again for your time, and we will end this webinar.
Thank you.
Thank you.
Thank you.